Welcome, students. Today we're going to talk about how the Supreme Court does its thing. We're going to go through the steps of a Supreme Court case, and it's a little different than sort of your standard court procedure, so pay careful attention to each one of the steps so that you'll know exactly how it happens. Just a quick review before we get into the details. Make sure you remember that there are 9 seats on the Supreme Court. That means 9 justices. One of those justices is a Chief Justice, and the other 8 are referred to as Associate Justices. And they have a schedule that runs from October to June. During that time, during the months of the year, they will hear about 100 cases. And these cases need to be sort of important constitutional question cases. What typically happens is people ask the Supreme Court to take their case, and this is done through a process called petition. Petition is the way that someone could ask the Supreme Court to take their case. Here's the court. It's just a slightly dated picture of the Supreme Court. I'll leave it to your own research to figure out which one of these justices is no longer with us. But at the time of this recording, we're sort of going through a transition in the Supreme Court. And we don't yet have the newly updated picture. So take a look at this one. You'll see some familiar faces. And these faces will carry us through the different steps. And we'll start with the step of petition. So a petition is a written statement sent by someone who is asking the Supreme Court to hear their case. So it can be a document, something as informal as this one here. This is a petition from the 1960s. From a case that's referred to as Gideon versus Wainwright. This happens to be the case where the decision to create the idea of public defenders was begun. This guy wrote his petition from jail. A simple handwritten note is all it took to get the Supreme Court to take that case. This is an example of a petition. Written statement asking the Supreme Court to review their case. So just because you write the Supreme Court doesn't mean that they're going to take your case. It takes 4 justices to agree to accept the case and to hear it. So this is referred to as the Rule of 4. And once the Rule of 4 is met, once 4 justices have agreed to take the case, it goes on the Supreme Court's docket for that year, and the process really begins. The court will issue what's referred to as a writ of certiorari. This is called the cert for short. It does several things, but the important things you need to remember is that it is the notification to all the lower courts, the trial courts or the appeals courts, that heard that particular case, that case that was petitioned, to send up all the records to the Supreme Court, because the Supreme Court is going to take this case on and make a decision, and they need all of the information that was generated by the lower courts in the trial and the appeals at hand, so that they can make what they deem to be the correct decision. Once the writ is issued and the Supreme Court has officially adopted the case, there are 4 main steps that each Supreme Court case goes through. The first step is briefs. The second is oral arguments. The third is conference, and the fourth is opinions. We're going to go through each one of these in turn and talk about some important details. So being a Supreme Court justice is kind of like being a student. You've got homework, you've got reading, you've got to listen to lectures, listen to spoken statements, and you've got to write. The first step in a court case is the one that most closely relates to kind of the homework phase for a student. So a Supreme Court justice doesn't have homework, but they have briefs. These briefs are written statements that are provided by both sides in the case, where they basically will write out their argument, whatever their statement or their stance on the given position might be. And the Supreme Court justices are expected to read these to become familiar with the situation of the case, the legal questions at hand, and what has happened with this case and the appeal process up to this point. After the briefs have been read and studied, there will be a brief session of oral arguments. And this is the part that looks most closely like a typical court case. You have, as you can see in the image, you've got the judges sitting at the bench. You've got the lawyers in front of them, and the lawyers are using this time to talk about the arguments that they're making, to pull the justices over to their side of the argument. This is also a moment where the justices will ask the lawyers quite a number of questions. The lawyers who are taking a case in front of the Supreme Court have to really be on their toes and be able to succinctly state their arguments and to respond to quite a number of questions from the justices. And you've got, instead of just one judge, you've got 9 judges looking down at you, and all of them can ask questions at any time. So once the judges have read the briefs and listened to the oral arguments, they meet together for a group session called a conference. The conference happens in a private room. It's just the justices that are present, and they talk with one another about what they feel like are the most important points of the cases that they're hearing. Also, during this conference, that the judges will try and persuade other justices to come over to their side, because the Supreme Court knows that the process of decision-making in this case is up to a vote. And you've got to get a majority vote in order to have one side, quote-unquote, win. So that's 5 votes. Justices may use this conference time to help pull other justices over to their side so they can get to that 5+ number of votes. So we have a vote. All 9 justices can vote. It's got to be a majority. So it's 5 or 6 or 7 or 8 or 9 votes to win. And whoever has the most votes, that's the side, that's the way that the court decides. After the court has made its decision, it needs to make a statement about why it made the decision that it did. And this is referred to as the opinion. This is the last step in a Supreme Court case. So what will happen is that you'll typically have at least one opinion that is written, and this is the majority opinion, the one with the most votes. One of those justices will write out, can end up being a fairly lengthy statement about why they decided the way that they did. This becomes really important so that people in the future can look back and really understand the reasoning and the reasons why the Supreme Court decided what it did at that time. You can have other opinions that are written as well. In addition to the majority opinion, you can have a minority opinion, which is a statement from the smaller side, 4 votes or less side, and this could explain why the justices in that smaller group decided something contrary to what the majority of the court decided. This is important because in many cases both sides of the argument might have some merit. It's just a matter of numbers as to which one won. And then the other 2 specific types of opinions that can come in to effect are dissenting opinions and concurring opinions. A dissenting opinion is a minority opinion. It's from the side that did not win, the smaller group. And this is typically an opinion that is written by a justice to describe why they disagree with the decision of the court. You can also have a concurring opinion. A concurring opinion is one that agrees with the decision of the court, with the majority opinion, but might reach that same conclusion for different reasons. So a justice may want to add views or stances that they have that agree with the majority opinion but aren't exactly the same. So there you have it. Those are the steps in the Supreme Court case, and we'll actually look at and listen to a few Supreme Court cases while you're in class. So bring your notes and your questions, and I'll see you then.